The bailiff had one hand on the door when a man the state had declared dead stepped into my courtroom and said very quietly, "I'm here." 3 people moved before I did. The woman at the defense table half rose so fast her chair scraped the floor like steel on bone. The attorney for the state snapped around and said, "No, Your Honor, this is improper." And the man himself, the dead man, took 1 step backward, as if he already understood the room had become more dangerous than any place he had hidden in for the last 6 years. I did not raise my voice. "Close the doors," I said. The bailiff shut them. The state's attorney was still talking. He should not be in this courtroom without counsel present, without advance notice, without... Swear him. That ended the noise for 3 seconds. In a courtroom, 3 seconds can feel like a verdict. The clerk stood. The witness lifted his right hand. I watched the woman at the defense table stare at him without blinking. 6 years in prison had hollowed her face, but it had not bent her spine. She never looked at me. She looked only at the man she had been convicted of murdering. "State your name," the clerk said. He swallowed once. "Thomas Ward." A sound left the back row then. Not a gasp, not a cry. The sound people make when certainty is dragged out from under them. I had seen murder confessions. I had seen juries shatter families in under an hour. I had seen liars perform grief with Oscar-worthy discipline. But I had never seen a dead man answer to his own name in open court, while the woman convicted of killing him sat 10 feet away in prison khaki. And that was not the beginning of the case. That was only the moment the lies finally ran out of hallway. 6 weeks earlier, the file arrived like hundreds of others do, overstuffed, desperate, and easy to dismiss. Routine appeal, post-conviction petition, 25-year sentence for the murder of a husband, wife convicted 6 years earlier. Prior motions denied, trial record thick, state's response thicker, the sort of file that arrives carrying its own burial instructions. I almost denied it from the bench calendar. That is the part I do not hide from you. Judges like to speak as if every turning point announced itself with thunder. It does not. Sometimes injustice wears the face of paperwork. Sometimes the most dangerous thing in a courthouse is a docket that is too full. I remember turning pages quickly. The prosecution's theory had been simple enough to fit on a campaign flyer. Husband disappears, blood in the truck, burned scene off a service road, wife has no alibi, marriage under strain, debt, argument overheard, ring recovered, enough circumstantial evidence, the state said, to let the jury do what juries do. The petition itself was handwritten in parts. That gets ignored more often than it should. People in prison write like they are pounding on the underside of a coffin. Most of it was what the state called recycled innocence claims. Wrong woman, wrong theory, leads ignored, detective biased, prosecutor reckless. I had read versions of that argument 100 times. Then a photograph slipped loose from the back and landed face up on my desk. Not evidence, not yet. Just a glossy print clipped to an affidavit from a private investigator no court had authorized, no prosecutor had requested, and no one in the trial record had mentioned. In the photograph, a man stood in front of a pale green house with a mailbox leaning left and an address half visible. He was older, heavier through the middle, wearing a baseball cap and carrying a grocery bag. He was alive in the most ordinary way a man can be alive. Inconvenienced, upright, mid-step. On the back of the photograph, a single line, Thomas Ward, Dayton, Ohio, 3 weeks ago. I did not call anyone in open court. I did not schedule the appeal. I put the photo back under the affidavit, closed the file, and told my clerk to bring me the state attorney general's secure line. She asked, should I notify counsel? No. That answer bought me 48 hours before anyone understood the case had changed shape. The Attorney General himself did not come to the phone first. One of his senior deputies did. I told him what I had in front of me. He said what careful lawyers say when a fact sounds insane. Your Honor, are you certain? No, I told him. That is why I'm calling you before I'm forced to say it out loud. He asked me to transmit the affidavit under seal. I told him I wanted 2 things done quietly and fast. Authenticate the photograph if possible, and find out whether anyone in law enforcement had ever chased a lead, placing Thomas Ward outside the state after the date he was supposed to have died. He said, if this leaks, it won't leak from me, I said. But courthouses leak the way old roofs leak. Never where you're looking, always where it hurts. The next morning, before the Attorney General's office had finished its first inquiry, the local prosecutor, who had inherited the state's side of the appeal, was standing in front of me, asking for summary dismissal. He came in hot, too hot. Your Honor, this petition is facially deficient, repetitive, unsupported by admissible evidence, and frankly an abuse of process. I asked him whether he had read the photograph attached to the affidavit. He blinked once and said, "A photograph proves nothing." I didn't ask what it proved. He shifted. "I've seen many fraud attempts in post-conviction filings." There it was. Not an answer. A shove. "Have you looked into it? We don't investigate random materials generated by convicted defendants desperate for attention." The woman at the defense table turned her head then. Not toward me, toward him. Just enough. Desperate for attention. That phrase stayed in the room like smoke. I set the file down and said, "Motion to summarily dismiss is denied. I want briefing. I want the original investigative file. I want chain of custody documentation for every physical exhibit used at trial. And I want your office to refrain from discussing this matter outside necessary litigation." He stiffened. "Your Honor, with respect, this is a finalized conviction." "With respect," I said, "not while I'm looking at it. If you think that is where the system corrected itself, stay with me. The system does not enjoy being told it may have eaten the wrong person." The woman's name was Elena Ward. At trial, she had been turned into a motive with a pulse. Every problem in that marriage had been arranged in neat moral order for the jury. Money trouble, shouting, a husband missing, a wife who could not account for one night, a detective who said she was cold, and a prosecutor who knew how to point to empty space and call it a body. I read the trial transcripts over 2 nights. I do not recommend that kind of reading before sleep. Every page carried the same perfume. Conclusion first, facts second. The detective in charge had centered Elena in the first 48 hours and never really left her. Neighbors who heard 2 voices arguing were emphasized. A gas station clerk who might have seen Thomas alone the next morning was minimized. An out-of-state credit card ping after the supposed murder was dismissed as a data error. A tip from a motel outside Cleveland was marked unverified and buried. A witness who claimed Thomas feared creditors more than his wife was impeached into near invisibility, and there was a line in the detective's supplemental report that made me stop reading and go back. Subject likely fled before homicide, staging impossible due to burn intensity. Likely fled before homicide. That line did not belong in the state's trial theory. It contradicted it. Yet it had not been disclosed in any meaningful way to the defense, at least not in a form anyone had ever argued to me. By day 3, the Attorney General's office called back. The photograph metadata had been partially preserved. The house existed. The address was real. Utilities at that address were linked to an alias. The alias connected to a Social Security fraud alert. A grocery store loyalty account captured the same face on internal security images. Not proof enough for a warrant, more than enough for dread. I set a sealed evidentiary hearing. That was when people started trying to kill the truth in earnest. The first attempt came in a motion filed after business hours. The state asked me to vacate the hearing, seal the entire docket, strike the photograph, sanction defense counsel, and transfer the matter to another judge due to what they called the appearance of procedural irregularity. Irregularity. When the state says irregularity, sometimes it means someone has finally looked under the rug. The second attempt came by phone, which I do not permit, and for good reason. A former prosecutor from the original trial team, now in private practice, now with his face on fundraising mailers if the newspapers were to be believed, asked through my clerk whether I understood the public consequences of entertaining conspiracy-driven petitions. I sent word back, file something or say nothing. He filed nothing. The third attempt was uglier. Elena's private investigator, the one who had found the photograph, reported that his motel room had been searched while he was at dinner. Nothing taken except copies of utility records he had left in a folder. That same night, the pale green house in Ohio went dark. Utilities cut, vehicle gone. Someone had warned someone. In court the next morning, the state asked for another continuance. "No," I said. "We may have parallel investigative interests," the prosecutor replied. "You should have had them 6 years ago." He did not enjoy that. The defense called the investigator first. Ordinary man, cheap suit, hands that shook only when he was still. He laid out how he had found the house through a skipped debt linked to Thomas Ward's old gambling circle. He had watched the residence for 3 days. He had photographed the man entering and exiting. He had followed him once to a grocery store. Then, on the 4th day, someone else arrived before dawn. Black sedan. No plates visible from the angle. 30 minutes later, the house went cold. The prosecutor was on his feet before the last word landed. Hearsay, speculation, vigilantism, no authentication. I let him speak just long enough to reveal his desperation, then cut him off. I'll decide what the witness saw. The defense offered the photograph. The state objected. Overruled. They offered a time-stamped receipt from the grocery store. Objected. Admitted for limited purpose. They offered a map pin placing the investigator at the address over multiple days. Objected. Admitted. Then the defense made its first mistake. They reached too early for certainty. Do you see in this courtroom the man you photographed in Ohio? The investigator looked around and pointed toward an empty space. No Thomas Ward yet. No dramatic identification. Just absence. The state smiled for the first time all morning. And there is your lesson. Truth does not enter to applause. It limps, it misses cues, it gives your enemy room to breathe. By the afternoon, the Attorney General's office requested an in-camera conference. Private. On the record but sealed. I allowed it. They informed me they had run fingerprints from an old employment application under Thomas Ward's alias against a federal database. Match probability was significant but not complete. The man had altered his grooming, lost weight, gained it back, moved twice, used cash heavily, and surfaced in records connected to illegal betting accounts and shell transactions already under separate federal scrutiny. Is he alive? I asked. The deputy AG answered like a careful man walking across rotten boards. We believe so. Believe. We do not yet have him in custody. The state prosecutor at counsel table said, this proves only that a man who resembles the alleged victim may have used his identity. I looked at him and said, you are using the word alleged in a very ambitious way. Elena sat through all of this without interruption. No theater, no outburst. Once, and only once, she placed her hands flat on the table and closed her eyes when the photograph was passed to the clerk. That was all. I had not heard from her directly yet. I wanted to. Not for sentiment, for precision. At the next hearing, I asked if she wished to address the court regarding the photo only. She stood. Chains moved lightly at her ankles. That's him, she said. No one breathed. How do you know? Because I was married to him. The prosecutor smirked a little. You also testified at trial that your husband was dead. She turned her face toward him. I testified the state buried me before it found him. That line hit hard because she did not raise her voice. Some people shout to be heard. The innocent often stop wasting the effort. Then came the first crack in the old case, and it came from a place the state assumed no one would look. A piece of land sold 6 months before Thomas Ward's supposed murder. The defense had subpoenaed county property records. On paper it was dull stuff. Parcel number, sale price, closing date. 2 sellers. One was Thomas Ward. The other was Detective Paul Hennessy, lead investigator on the case. The courtroom changed temperature. The prosecutor objected before the deed even reached the witness stand. Relevance. I asked him to sit down. Hennessy had already testified once in the original trial. Straight-backed, professional, certain. In my hearing, under fresh subpoena, he arrived with the posture of a man accustomed to being believed on sight. He told me he knew Thomas only casually, through local real estate investment circles. Casual. That word lasted under oath for less than 4 minutes. Defense counsel handed him the deed. Is that your signature? Yes. And this closing statement showing disbursement of $60,000 to you? Yes. And this was with Thomas Ward? Yes. Yet in your original testimony, you described your relationship as limited to prior police contact and neighborhood familiarity. The detective reached for water. Missed it. Found it on the second try. We weren't social friends. The defense took one more step. Did you disclose this financial relationship to the prosecutor? I don't recall. Did you disclose it to the defense? I don't handle disclosures. That answer traveled through the room like a bad smell. You tell me what it is when the lead detective profits $60,000 with the victim half a year before deciding the victim's wife must be the killer. I asked him directly, Detective, were you ever in debt to Thomas Ward? No. Did Thomas Ward ever threaten to expose any financial dealings between you? No. Did you investigate the possibility that Mr. Ward staged his disappearance? We considered all reasonable theories. Show me where. He could not. Not in the report. Not in the supplemental. Not in the logs. Not in the witness list. Not in the subpoenas. Not in anything. The state asked for a recess. I denied it. By then the old conviction was bleeding through the bandages. And still we did not have Thomas Ward in custody. Remember that, because this is where most people think the case would become easier. It did not. Once powerful people understand that a lie may be exposed, they do not surrender the lie. They lawyer it, they delay it, they spread the blame until the truth looks indecent for asking to be specific. The former prosecutor from the original murder trial finally appeared through counsel, not as a witness yet, but as a problem. He moved to quash subpoenas for his campaign communications, internal memos, and trial preparation notes. Privilege, harassment, political theater, fishing expedition. He used every phrase available to a man who does not want yesterday read out loud tomorrow. I read the motion, then I read the timeline. 3 weeks after Elena Ward's conviction, he launched his campaign for Attorney General. The conviction was on the first page of his announcement mailer under the phrase "tough enough to deliver justice." 2 staff emails produced by mistake in related discovery referred to the Ward case as "our signature closed before announcement." Another told a junior prosecutor, "Keep the defense nonsense boxed out. Verdict must stay clean through summer." Must stay clean. That phrase bothered me even more than desperate for attention. At the hearing, his lawyer argued those communications were irrelevant. I asked, is a prosecutor's personal electoral interest in preserving a weak case irrelevant? We dispute the characterization weak. You may, the documents do not. He objected to production. I ordered it. The next morning, before the records were due, federal agents arrested Thomas Ward in a rented duplex outside Reno under an alias tied to betting accounts, mail fraud, and identity falsification. The Attorney General's deputy called Chambers himself. "We have him. For what? Enough to keep him breathing where we can find him. Bring him back. We're starting extradition. Start faster." That was the first moment in weeks the state's inherited trial attorney stopped fighting me and started looking afraid of other people. I did not let up. While extradition was pending, we continued. That is when the burn evidence collapsed. At trial, the state had argued a body was effectively destroyed in a vehicle fire, intense enough to erase certainty and leave only fragments. Fragments had done heavy lifting in that courtroom years earlier. A wedding band said to be Thomas's, dental chart comparisons built on partial remains, blood in the truck cab matching him, and expert testimony that no one could have walked away. But the new hearing brought a forensic analyst from the Attorney General's office who had re-examined the evidence chain. She testified that the wedding band was a common commercial model sold in the thousands. The dental comparison had relied on incomplete charting and assumptions supplied by investigators. The blood in the truck cab proved injury, not death. Most damaging of all, the fire patterns were consistent with accelerant introduced after the truck was abandoned, not during an active struggle. The state tried to box her in. "Are you saying the original experts lied?" "I'm saying they answered the questions they were asked." That line made the prosecutor sit down slower than usual. Then the defense played the motel card I had seen buried in the old report. A former night clerk from outside Cleveland, now retired, took the stand with reading glasses in one pocket and no patience left for legal games. He identified Thomas Ward from a recent photo spread and from a 6-year-old registration card signed under an alias one day after the supposed murder. The state objected to the identification, overruled. They objected to the registration card, admitted. Then they did what lawyers do when facts refuse to die. They attacked memory. "Sir, are you telling this court you remember one guest from 6 years ago?" The clerk shrugged. "Not at first. I remembered the wife." The room tightened. "What wife?" "The one who called 2 days later, asking if a man with a broken knuckle had checked in." I told her yes. She started crying, then hung up. Every head turned toward Elena. She had never said this to me. Maybe no one had ever asked properly. Maybe no one wanted the answer. The prosecutor snapped. "This was never in the record." Elena spoke without waiting. "Because my lawyer told me without proof it would sound crazy. There are many ways to fail a defendant. Some are malicious, some are polite. If you have ever wondered how an innocent person gets convicted when the truth still exists somewhere in the world, here is one answer. The truth arrives in pieces, and every piece is treated like a nuisance by someone whose career depends on the simpler story. By the time Thomas Ward was extradited, the old case had become almost unbearable to watch. Not because it was complicated, because it was not. Underneath all the legal scaffolding, it was a very old human pattern. A coward with debts found easier shelter in a woman's ruin than in his own accountability, and other men saw something useful in helping him. He entered my courtroom in a suit borrowed from a county transport unit, cuffs removed only after the door shut. The same courtroom where, 6 years earlier, his absence had been turned into proof of murder. This time he was present, and presence is a merciless witness. I asked him whether he understood why he had been brought before the court. "Yes." "State your name." He hesitated. The Deputy Attorney General said, "For the record." I held up my hand. I asked him. He looked at the defense table once. Elena did not look back. Thomas Ward. The old state prosecutor's office had sent a representative, though they no longer led the matter. I saw him write something immediately and slide it to counsel. I saw counsel shake his head. Even then, even with the dead man breathing under oath, instinct told them to manage, contain, narrow, survive. Mr. Ward was advised of his rights. He invoked them selectively, which is the refuge of cowards, who still believe they can negotiate with gravity. The Deputy Attorney General began with the alias, the addresses, the betting accounts. Ward admitted enough to establish identity and movement. Then he started fencing. He said he fled because creditors threatened him. He said he panicked. He said he intended to come back when things calmed down. He said he never expected Elena to be charged. He said he assumed the police would determine he had disappeared voluntarily. I let him say all of that. Then I asked one question. "Who placed your wedding band in the burned truck?" He looked at his lawyer. "Mr. Ward," I said, "look at me." He did. "Who placed your wedding band in the burned truck?" Silence. The Deputy Attorney General slid a document onto the projector. Property records, then betting ledgers. Then a phone log showing repeated calls between Thomas Ward and Detective Hennessy in the 10 days before the supposed murder, and 2 calls from a prepaid phone to Hennessy the morning after. The detective had denied ongoing contact. The records did not. The courtroom shifted again. Ward's lawyer objected. Foundation, prejudice, scope, overruled. Then came the final pressure point. A federal proffer note from Ward's fraud case, indicating he had discussed the wife solution with a local friend who knew how scenes get read. The identity in the note was not named. It did not need to be. Hennessy, sitting in the second row under subpoena recall, stood up halfway as if to leave. "Sit down," I said. He sat. Ward's mouth opened, then closed. He pressed his lips together so hard the color left them. The Deputy AG asked, "Did you stage the scene?" No answer. "Did you let your wife go to trial for your murder?" No answer. I leaned forward. "Mr. Ward, this court is already beyond shocked. You will not protect yourself with silence after 6 years purchased by another person's life." He wiped his face with the heel of his hand. "I didn't think it would go that far." Those were his first honest words. Elena made no sound. She only gripped the table edge until her knuckles whitened. The Deputy AG kept going. "Who helped you?" Ward looked back again, not at Elena this time, at Hennessy. You could feel the room become dangerous. "No one," he said. The Deputy AG placed one more document on the screen. A bank transfer made 2 days after the staged death from an account linked to a shell entity into an account later used by Hennessy's brother-in-law. Same amount as a gambling marker Ward had been carrying. Not proof of everything, enough proof of something. Hennessy stood again. "I want counsel." "You should have wanted conscience," I said. Then chaos did what chaos does when truth finally finds the right artery. Hennessy's attorney demanded a recess. Ward's lawyer advised his client to stop speaking. The former prosecutor's counsel objected to any suggestion of his client's involvement absent direct evidence. The Deputy AG moved for immediate arrest of Hennessy on perjury and obstruction grounds pending fuller charges. Reporters outside had begun to hear movement through doors they could not open. My bailiffs took positions without being asked. And in the center of it all sat the woman who had already served 6 years for a murder no one in that room could any longer defend. I called the room to order once, then twice. Then I said the only words that mattered: vacate the conviction. No one moved. "Now," the clerk began. The state, to its credit at the very end, did not oppose. They could not. Some cases end with argument. This one ended with surrender. I ordered Elena Ward released immediately. No applause, no cheering. Courtrooms are not theaters, and when the damage is that large, noise would have insulted it. The chains were removed. She stood there a second longer than necessary, as if her body did not trust sudden permission. I asked if she wished to say anything. She looked at Thomas Ward first, then at me. I told them. That was all. What could improve on it? Later, after the extradition paperwork settled and additional charges were filed, fraud, perjury, conspiracy, obstruction, false statements, and more still rolling in from other jurisdictions, I had Thomas Ward back before me on related proceedings. Hennessy had counsel and no easy answers. The former prosecutor was under investigation, his campaign language now evidence instead of advertisement. The state was forced to account not only for one false conviction, but for every hand that helped steady it. People always want the ending to sound triumphant. They want a clean blow, a righteous sentence, a quote that closes like a vault. But justice is not neat when it arrives late. I looked at Elena Ward on the day her record was cleared in full. She wore civilian clothes that did not quite fit right yet. 6 years had been taken out of the center of her life and laid where no judge could reach them. Her mother had died while she was inside. Her house was gone. Her name had spent 6 years in headlines beside a word that should never have touched it. I sentenced the men according to law, where law permitted me to do so. I used every inch of the record, every lawful finding, every hard fact, stripped clean of excuse. But before I concluded, I said what needed saying plainly, because sometimes the bench must stop speaking in codes. She lost 6 years, I said. There is no sentence I can give that repairs that. No one objected. No one could. If you ask me what I remember most, it is not Thomas Ward walking through the courthouse door very much alive. It is not the photograph, not the property deed, not the campaign emails, not even the moment the conviction fell apart under its own dishonesty. It is the silence after Elena Ward was told she could go home. I have presided over loud victories, families embracing, lawyers crying, reporters running, deputies opening pathways through crowds. This was not that. This was a silence so complete you could hear paper settle. A silence that said every person in that room understood the same thing at the same time. The law had finally done right, and it had done it unforgivably late. That is the part I carry. Because a courtroom is not holy because a judge sits in it. It is only as honorable as the people willing to stop a lie after the lie has become expensive to stop. On that first day, with that file on my desk, I nearly moved too fast, nearly trusted the shape of the paperwork, nearly helped the state bury a living man a second time, this time on paper, which is where the worst burials happen. I did not. And because I did not, a dead man had to stand up and answer to his own name.